One. Hello, everyone, and thank you guys so much for joining us here today. I am joined by our awesome managing attorney, Ruby Powers. Round of applause, everyone. Thank you. Today, she is going to be discussing on immigration court and why not to wait last minute. Super important, guys. Cannot stress this enough. Just a little bit background on our managing attorney here. Ruby Powers has been licensed since 2008, and she founded our firm November 2009. So PLG has been, going strong for a couple of years
everyone,
now.
and thank you guys so
Whoa.
much for joining us here today. I am joined
Sorry
by
about
our
that,
awesome
guys.
managing attorney, Ruby Powers.
We're having some feedback.
Today,
Sorry about that. We're streaming live, so sometimes we have some technical difficulties. But going back to our attorney Powers here, her background, she is also an author. So some of you guys didn't know, she is a published author for Build and Manage Your your successful immigration law practice without losing your mind. It's a really good read. 10/10 would recommend. And also, she founded Power Strategy Group in 2020. So Ruby's been doing some big stuff in the background. I'm gonna go ahead and let Attorney Powers take it away with our learning objectives. And feel free to drop down any comments down below in the Q&A, and we will be sure to answer them at the end.
Thank you. And all of this is being recorded, so if you didn't catch it, or if you're probably watching it or you don't get to watch the whole thing or whatever, we're going to be posting this up on live on YouTube. So thank you so much for joining us, Immigration Court. Don't wait till the last minute. We put this on because Immigration Court in the Houston area is currently not holding hearings. Let's just say it like that. They're open for filings, but they are not conducting master calendar or merits hearings in the non-detained court in Houston. Now, we are located in Houston, Texas, but immigration is federal, so we have clients all over the US. We have flown I can't even name all of the places. Pretty much anything that's within about an hour Southwest flight, we have been there on a regular basis, north, south, east, west, everywhere. And also even into the East Coast. We actually have cases all over the country. So if you are watching and you're interested in our services, we can work with you. And lots of things are being done remotely and through televideo in the future. So we think that there will be more capability of remote representation. So we wanted to talk about what's going on with the immigration courts, just briefly go over the forms of relief sought generally, some court operation updates, and the future of courts. And so we'll go over that with you. So the immigration court is under Department of Justice. And the part that holds the court is the Executive Office of Immigration Review, which we call UIR for short. And in general, so we have a new Attorney General, and there's just basically being a change. So it's a little crazy to think, we had a few attorney generals under the Trump administration, and then we had COVID, and then we are here we are, and we have a new president, we have a new attorney general, but yet the courts are not technically holding hearings in the Houston area. So there's a lot of changes are going on behind the scenes. And we're wondering what the world's going to look like in immigration court once they do open. But they've had a lot of time to get organized, to clean up, to get ready to come up with a bang. And so we don't know when that will be, because right now they're currently around mid-June is the date. But what we anticipate is to find out soon whether or not this is being moved further into the summer, or if we're going to open up around that mid-June date. So under Trump, there was one. Now we have 1.3 million case backlog in immigration courts. 1.3 million. That's a lot. Let's just take that in for a second. Non-detained court remains closed until mid-June, like we said, in the Houston area, but the detained courts have never closed. But we have seen that those who are detained don't stay detained very long. They seem to be pretty lenient in some capacity, releasing people through parole, bond, or humanitarian reasons of some sort. There was a Greens Point Park Immigration Court that was that has been opened in mid-March, so just 2 months ago, and there's more judges coming onto the bench. The Remain in Mexico, also known as Migrant Protection Protocol, is being phased out, and those who've been waiting are being reintroduced to coming into the United States to wait their hearing. But for the most part, while I'm talking about it, most people are not able to come into the United States because of Title 42, which is basis under the CDC recommendations for health purposes, which was put into place under under Trump. Anyway, we have only seen pretty much adults with minor children, pregnant women, and unaccompanied minors being able to come across the border for the most part these last 5 months or so. And there is actually, I was on some calls this week about whether or not they're going to have waivers of Title 42 potentially in the future, because it doesn't seem to make sense that they're using Title 42 as well, it's basis on is health purposes, but then they're easing a lot of things with the CDC, but then it's sort of like there's waivers for certain nationalities, but not others. And so it doesn't seem like it's necessarily a health basis, but there's an excuse. When I do a lot of these talks, I mentioned that advocates prefer that if we were to be able to have Article 1 court status, where there'd be more independence and efficiency, and we could work towards getting rid of this backlog. But right now we're Article 3 courts, where they are under the purview of the executive action. I'm sorry, not executive action, but not as independent, and so they are currently under the UIR. And the judges don't have as much independence as they would as the Article 1 courts. So some people they argue that if we were to have more judges, we'd be able to get rid of the backlog. But reality is the judges haven't been able to administratively close cases, terminate cases, and there's a lot of inefficiencies having to wait for USCIS to adjudicate things. So there's a lot of ways to do things more efficiently besides just having to get more judges for the cases. When you do apply for a form of relief, we call those form of relief when you're applying in court. There's lots of different things. You could be applying for a bond to be released from detention, a cancellation of removal. There's for legal permanent residents and non-legal permanent residents. You could apply for adjustment of status. You might be applying for waivers, asylum. There's also you could have a U visa. You could apply for DACA or TPS. There's really plenty of other options. It's just that one of the reasons why we did this is because even though in Houston, immigration courts are not having hearings right now, if they do open in 1 month, and then you get a hearing and you don't have a attorney, or you didn't do a Freedom of Information Act request, or you don't have your form of relief ready, then you're going to be moving really quickly. And I'm just anticipating a lot of people are going to start getting hearings and realizing they're not going to quit getting these postponements and continuances. And then they're going to start running to attorneys, but attorneys can only handle so much work at one time. And it's generally better to do this work when you're not in a rush. So just because you maybe have a hearing later in the year or next year, don't wait to the last minute, because we might need to do a Freedom of Information Act request. We might need to petition for somebody else who can petition for you. It could take time. And that's what's really the biggest message. So don't wait to the last minute. Also, there could be something you're eligible for now. For example, Venezuelan TPS is only available till September of this year. You don't want to wait for that. Or maybe you could, if you apply for DACA, and then that can make us eventually be able to administratively close your court case if we can eventually do that. So don't wait till the last minute. I'm going to keep saying that a few times, I think. So, the courts are remaining, I don't like to say the word closed necessarily, because there's still having taking filings and answering calls and things like that, but they're not having master calendars or merits hearings. One of the biggest tricks whenever we have a consult or whenever we try to empower people is the 1-800 number, the 1-800-898-7180, and you put in your A number, and then you click a couple buttons, and then it'll tell you when your next hearing is, if you have any dates for your work authorization clock, and when, or if you've had a hearing, they might tell you briefly a little bit of what the result, especially of an appeal. So this is really important. For example, let's say you had an attorney and you want to change to another attorney or what have you. The thing is, with immigration court, they only send the notice to one person. It's either your attorney of record or yourself. So if you move and you don't change your address within 5 days with immigration court, then you're not going to get the hearing notice. Or let's say your attorney moves, or maybe they lose track of you or something like that. So it's always important for you to take control of your own situation and call the 1-800 number occasionally and just double check, because immigration court has been moving dates early, pushing them off, moving them early. I mean, it's insane. In fact, I mean, I still have cases I've had for 10 years at this point. Like, we're gonna all grow old together, basically. But a lot of times when I have a consult, people don't know about this 1-800 number. And I'm like, no, please, I want you to know this number. Like, I have it memorized, actually. Like, I have my fingers memorized. I don't remember the number. I just go do. And because I call it so frequently with my, in my consults. And so it just gives you a little bit of a peace of mind. The non-detained hearings, right now it's June 11th. That's the date. Now, you know how we find out, right? It's through tweet. So the EOIR, the DOJ EOIR is going to tweet us the update. Probably maybe another week or two, we might find out what's going to happen, if we're going to play ball in after June 11th, or if it's going to get postponed. We're getting close to the summer. There's the 4th of July. I wouldn't be surprised we get into some July-ness. I don't know. Usually the immigration court judges, they usually have, I think, a conference at the end of June or something. So I wouldn't be surprised if it just gets pushed to July, but we don't know. Any moment now, so don't wait till the last minute. Let's see, the rotating immigration judge schedules are no longer available on the EOIR website. They've stopped providing the rotating schedules. The schedules were posted on the OER website in February in response to the American Immigration Lawyers Association's concerns that they were not giving insufficient advance notice. So by checking the automated case information online system or the hotline, this is pretty much what we're saying. You have to have multiple. If you have an attorney that has attorney of record, we generally can see some of the information on the online system, but also the phone number is another great source. So the future of immigration courts, as of the end of April, a total of 8,387 individuals formerly forced to remain in Mexico have been able to enter. So that's a great win. I'm so grateful for that. Wow, a lot of them through El Paso versus the other locations. So those are the folks that are able to come in, as well as those pretty much are pregnant, small minor children, or unaccompanied minors. But for the most part, we're hearing reports that people are not being able to come in because of Title 42. The UIR rescinded a policy memo on case processing, returns the case management system established by regulations effective of September 25, 2002 to manage the board's caseload. So I think this will streamline the processes in the future. And they are hiring more immigration judges and putting them on the bench. We're getting reports of those being put on the bench on a regular basis. There was a case recently that could save many people from deportation and maybe get rid of a lot of that backlog. But basically, it was just a couple of weeks ago, they issued a decision in Ms. Chavez. The court held the charging document for a removal proceeding, the notice to appear, is invalid if it does not specify the date and time of the hearing. So there were a lot of notice to appear that were sent out. and it would say to be determined, or they would, they would get the notice to appear out so that they later would follow up with a date and time when they got it in their system. So those ones that don't have the specific date and time on it, you could then go in and use it to terminate proceedings. Now, sometimes you might want to be in court because then you're eligible for cancellation of removal or what have you. But many times you might say, I don't want to be in court. Let's go do something with USCIS and let's get out of court. Because pretty much for the most part, immigration court, you're there, you either win something or you get the deportation order. For the most part, it's pretty like the last stage, so it's serious. So this is exactly how the Supreme Court ruled in 2018, 3 years ago in Pareja v. Sessions. However, during the last 3 years, the government has issued numerous tactics in an attempt to limit the court's ruling to make it more difficult. So even if the NTA does not specify the date and time, a subsequent notice could cure its failure to do so. That's the way the administration had been trying to, the Department of Justice under the Trump administration was trying to say. So what am I saying? What were you saying, Ruby? Okay, bottom line. If you got a notice to appear and it didn't say a date and time, then it's not a valid notice to appear, and you could use that to terminate the proceedings. So go look at your notice to appear. If that first one didn't have it, then that, did they ever give you, this also affects the time, the clock's time, stop time rule, because if they gave you one that was deficient and then later gave you a better one, then you would use the better one as the stop time rule for your cancellation of removal. And why am I saying all that? Well, it means is like when you get a true NTA that's not deficient, notice to appear, that stops the clock for cancellation of removal purposes, and it can have a big impact on the rest of your case. So I guess if this is confusing, what I'm trying to say is go talk to immigration attorney, or go, if you have one already or you want a second opinion or what have you, then just go look into it, because you might be able to either get terminated or you might be eligible for cancellation that you weren't before, because now you might have more time, and the stop time rule is getting moved because of this new ruling that came out only a couple weeks ago. So you where to find us. We're here Tuesdays at 5 Central and Fridays at 11. And why don't you tell them when what's the next topic for next week?
Yeah, of course. So again, thank you guys. We always really do enjoy having these webinars with you all. Can you guys hear me?
Yes. Yeah. I just realized we have a slide. That's why.
Yeah. So we do have a slide here for our schedule for our webinars. So upcoming next, we're going to be talking about adjusting through PERM, a guide to navigate the PERM labor certification process. So very hot topic. I think it's been might be a trend or something that we just want to talk about that we haven't mentioned previously. And, we do want to be a trusted and reliable source for immigration information with our trusted attorneys here that we have. So we hope to see you all on these upcoming webinars. We will have it on our website at rubypowerslaw.com. You can go and see it on our upcoming webinars. It's in our blog right up at the top, so you can't miss it. And really fast, I would super urge you guys to subscribe to our social media and also to our newsletter that goes out bi-weekly. You can just hold up your phone right here next to this QR code, scan it on your camera, bam, you're already in. Just plug in your info and you're set. And we hope to see you all on the next one. And it's always a pleasure being able to give you guys this immigration information with our experienced attorneys. Attorney Powers, do you have anything else you'd like to add?
Well, like the title says, don't wait till the last minute. If you have a case that either you want a second opinion or you haven't found an immigration attorney yet, or you had a consult a long time ago, you were looking for an attorney, but you didn't hire one. This is the time to do it. This is the time. It's a little quiet right now. we're waiting for court, but a lot of us are ramping up because we know that once court opens, I mean, it's going to be like the floodgates with cases and filing. So we had scheduling orders earlier in the year, December, January, February. We got a lot of our cases done in that respect, but we do have the capability of taking new cases here at Powers Law Group. You can give us a call. We speak Spanish, English. We can help work with a translator for other languages. 713-589-2085, and we can work with you over Zoom, phone, and different time zones. But I really just don't wait till last minute. Like, if you want really good representation, if you want to get the best result possible, very likely we're gonna have to get a copy of your file. We're gonna have to do a Freedom of Information Act request. We're gonna need to research what's going on right now in the case law today. And it just takes time. And anything good, it takes time, and you don't want to be rushed. And I really hate it whenever I think that we're not going to be able to do the best thing we can for our clients because we're in a rush posture and sort of a little so we don't do that to yourself, because we want the best for you. And even though it seems as like it's been quiet, make sure that you look into it and don't delay, because you and your life and your family's life are all in limbo until this gets resolved. So thanks so much for watching, and we look forward to seeing you at the next webinar or in a consult.
Thank you guys, and I hope you all have a great rest of your